Welcome back to Canadian Justice, where we're discussing what's been going on at the Public Order Emergency Commission, or the Rouleau Commission, this inquiry looking into the government's justification for invoking the historic Emergencies Act. So, Joanna, let's talk about that legislation. What is the threshold for invoking that Emergencies Act? What does the commission need to learn in order to find that the use of the act was justified or not justified?
So there's a few steps that I'll have to go through, but I really think it's worthwhile because I feel like this has kind of been lost in the mix of all this voluminous evidence that we've been hearing.
And really, this
But
is the most important question.
it is. So the government has asserted that it was a public order emergency, which is defined in the Act as an emergency that arises from threats to the security of Canada and that is so serious to be a national emergency. And I'll mention what threats to the security of Canada are defined as in a moment. But also important to mention that in order to be invoked, the crisis has to exceed the capacity of a province to deal with. And we'll talk about Ontario's contested role in this commission or non-role, as the case may be. As well, the provinces have to be consulted. We know that the provinces feel they were not consulted, and Parliament has to approve it. But let's go back to threats of the security of Canada. They're pretty specifically defined. A, espionage or sabotage. B, foreign influenced activities. C, unlawful acts that are intended to lead to the overthrow of the government in Canada. Lawful protest is excluded except in combination with those. So we're talking about very specific things that we certainly haven't seen a scintilla of evidence of in these hearings.
So let's talk about that role of the Ontario government. So the one thing that has been a really interesting development is some evidence that the provincial government didn't participate in these tripartite conversations, that the provincial government could have used powers under their emergency legislation and didn't. And that's why the Canadian Constitution Foundation, we sent a letter to the commission asking that they call Premier Ford as a witness to testify at the inquiry. Now, Ford had said he wasn't going to testify because no one asked him. We received a reply from the commission that said they had asked the premier and former solicitor general multiple times to appear and that they declined. They then issued a summons in response to our request, summoning the premier and solicitor general, former solicitor general, to appear. What has happened now?
So now Premier Ford has brought a judicial review contesting the summons, claiming that he is preempted by parliamentary privilege as a member of the Ontario legislature from being summoned to give evidence. And look, on the law, he very well may be right. Nonetheless, it's fairly jarring that the premier of a province, which is host to Ottawa, which contrary to popular belief, one of his talking points has been that this is a federal matter or just a policing matter. Just because the protests happen in Ottawa doesn't mean it's a federal matter. It's Ottawa is a city in Ontario, and it's important for us to understand what his thought process was in whether he considered invoking the Provincial Emergency Act, what his interaction was with the OPS and the OPP. And so it's really relevant to the question of whether this situation could have been dealt with under any other law in Canada, which is in some ways the crux of the matter. It's really the focus of the CCF's submissions. So I don't know how this is going to play for him. I mean, it's outside of the scope of our expertise to muse on why he's doing it, but clearly some of the optics may not be particularly politically flattering for him if he were to come, but it's still fairly shocking that he's refusing to participate.
Yeah, and that he said that he was not asked, but it turns out he was. And it's all something.
Depends on
So,
what you mean by asked.
yeah,
You
you're
know,
right. One of the things that I want to talk about is what powers the premier could have used, because he had invoked a provincial state of emergency. But the powers under a provincial state of emergency are very different from Federal Emergencies Act. We've got about a minute. What can you tell us about those two different laws? And what makes the Federal Act so exceptional?
Well, the Federal Act, of course, applies across Canada, and it gives extensive powers to enact new criminal laws, sweeping powers that applied not just in Ottawa, but in every inch of Canada.
Which the government used. They did enact new criminal laws. These
Right.
regulatory, these regulations that allowed for the freezing and seizing of assets.
Yeah, so you wouldn't have seen the economic measures if there had been a provincially declared state of emergency.
And I think that the premier could have used a lot of his powers under that provincial state of emergency. And there were existing common law powers that police have to create barrier zones that they could have restricted access to that red zone in Ottawa. We've got to go to commercial break now, but we'll be right back.